granting of a patent on a product does not give the patent owner an affirmative right to sell the product. A patent provides only a right to exclude. Often the government can impose requirements on a seller, even a patent owner, before a product can be sold. The best example of these points is the field of pharmaceuticals. A company can obtain a patent on a chemical compound that becomes the basis for a pharmaceutical product. A company can also obtain a patent on the use of the pharmaceutical product for a specific form of treatment. In addition, a company might obtain a patent on a medical device used to treat or diagnose a disease. But before any of these inventions can be sold, the patent owner has to obtain marketing authorization from the Food and Drug Administration, or FDA. In this session, we explore the process for obtaining FDA marketing approval and its implications for patent law and for competition. We begin by highlighting the main points about the FDA process, specifically the New Drug Application, or NDA, and the Abbreviated New Drug Application, or ANDA. We then discuss the need for patent term extension to accommodate the FDA process. Finally, we turn to the issue of generic drugs, which enter the market once an existing pharmaceutical goes off patent. Two big sets of issues inform the discussion of generic drugs. The first relates to the special FDA process for allowing generic drugs to enter the market. The second are the controversial antitrust issues arising from reverse settlements, through which a patent owner pays a potential generic drug manufacturer not to enter the market. For decades, the regulation and control of new drugs in the United States has been based on the New Drug Application. Since 1938, every new drug has been the subject of an approved NDA before U.S. commercialization. The NDA application is the vehicle through which drug sponsors formally propose that the FDA approve a new pharmaceutical for sale and marketing in the U.S. The data gathered during the animal studies and human clinical trials of an investigational new drug become part of the NDA. The goals of the NDA are to provide enough information to permit FDA reviewers to reach the following key decisions: whether the drug is safe and effective in its proposed use, and whether the benefits of the drug outweigh the risks; whether the drug's proposed labeling, package insert, is appropriate and what it should contain, and whether the methods used in manufacturing the drug and the controls used to maintain the drug's quality are adequate to preserve the drug's identity, strength, quality, and purity. The documentation required in an NDA is supposed to tell the drug's whole story, including what happened during the clinical trials, what the ingredients of the drug are, the results of the animal studies, how the drug behaves in the body, and how it is manufactured, processed, and packaged. An Abbreviated New Drug Application, or ANDA, contains data to support the review and ultimate approval of a generic drug product. A generic drug product is one that is comparable to an innovator drug product in dosage form, strength, route of administration, quality, performance characteristics, and intended use. They offer consumers a safe, effective, and low-cost alternative to the original brand name drugs. Generic drug applications are termed abbreviated because they are generally not required to include preclinical, animal, and clinical, human data to establish safety and effectiveness. Instead, generic applicants must scientifically demonstrate that their product is bioequivalent, that is, that the product performs in the same manner as the innovator drug. One way scientists demonstrate bioequivalence is to measure the time it takes the generic drug to reach the bloodstream in healthy volunteers. This gives them the rate of absorption, or bioavailability, of the generic drug, which they can then compare to that of the innovator drug. The generic version must deliver the same amount of active ingredients into a patient's bloodstream in the same amount of time as the innovator drug. Using bioequivalence as the basis for approving generic copies of drug products was established by the Drug Price Competition and Patent Term Restoration Act of 1984, also known as the Hatch-Waxman Act. This act expedites the availability of less costly generic drugs by permitting the FDA to approve applications to market generic versions of brand name drugs without conducting costly and duplicative clinical trials. The requirement of pre-marketing approval before selling pharmaceuticals has implications for patent law and the commercialization of patented inventions. The patent owner of a new pharmaceutical cannot begin to market the drug upon the grant of the patent. Instead, the patent grant has to be coordinated with FDA approval. However, FDA approval may delay the marketing of the patented drug and thereby effectively reduce the term of the patent. The Hatch-Waxman Act allows the patent applicant to petition the USPTO for extension of the patent up to a maximum of 5 years in order to compensate for administrative delay resulting from FDA approval. This patent term extension allows the patent owner to obtain close to the full period of patent protection. Note that at the time of the passage of the Hatch-Waxman Act in 1984, the patent term was 17 years from the time of grant. Now the patent term is 20 years from the time of the filing of the application. In theory, once the patent expires, then anyone is free to manufacture and sell the previously patented drug. But the entry of generic drugs is not automatic, because firms wishing to sell generic drugs have to get approval from the FDA through the ANDA process. If the generic company had to wait until after the patent expired to begin the process of seeking FDA approval, the original drug would get an additional period of market exclusivity until the FDA process was over, which would effectively amount to an extension of the patent term. To avoid this situation, the Hatch-Waxman amendments to the Patent Act provide that it is not infringement to make or use a patented invention if reasonably related to the development and submission of information under the Food, Drug, and Cosmetic Act, the law establishing the FDA. This provision enables generic drug manufacturers to use the patented invention to undertake the clinical studies necessary for FDA approval of the generic version of the product, so that they will be ready to begin marketing the generic drug as soon as the patent period is over. It is often called the safe harbor provision because it protects generic drug sponsors from litigation. The 1990 Supreme Court decision in Eli Lilly v. Medtronic illustrates the safe harbor provision in the medical device context. Medtronic sought to market a generic defibrillator to compete with the one sold by Eli Lilly once Lilly's patent on the medical device expired. Medtronic used the patented invention in undertaking clinical studies for the purposes of FDA approval. Eli Lilly sued for patent infringement. The Supreme Court ruled that the provision permitting acts reasonably related to the development and submission of information to the FDA applied to medical devices and not only to pharmaceuticals. The court reasoned that the policies regarding term extension applied equally to medical devices. Therefore, Medtronic's unauthorized uses of Eli Lilly's patents were protected by the Hatch-Waxman Act. In submitting its NDA, a patent owner has to disclose any patents on the chemical compound or use thereof that would cover the pharmaceutical for which it is seeking marketing approval. The FDA records the patent owner's information about patents and about protected uses of the pharmaceutical in a document titled Approved Drug Products with Therapeutic Equivalence Evaluations, which is commonly referred to as the Orange Book. Patented uses of the chemical compound are known as use codes in the Orange Book. The FDA does not review what the patent owner reports, but simply records it to aid in approval of generic products in the future. When an ANDA is being reviewed, the generic drug manufacturer must attest that the generic compound does not infringe a patent before the FDA will grant approval. If there is an unexpired patent on record in the Orange Book, and this patent overlaps with the generic drug, then the FDA will deny approval. The ANDA applicant can respond by showing that no patent information has been provided to the FDA, showing that the patent has expired, demonstrating that the generic drug will not be marketed until after the expiration of the patent, or asserting that the patent is invalid. These 4 options are listed in the Hatch-Waxman Act as separate paragraphs. In addition, the party seeking approval under the ANDA can claim that the generic drug will be for a use that is not covered by an unexpired patent. This approach is available if the patents on the underlying chemical compound have expired, and the only existing patents are those covering particular uses of the drug. If the FDA approves the ANDA on this basis, the generic drug label must clearly carve out the exceptions for which the generic drug has been approved. However, if there is any overlap with the use code in the Orange Book, then the FDA will deny approval. The FDA's role is ministerial and automatic in enforcing the patent rights recorded in the Orange Book. The FDA lacks the expertise to ascertain the validity of the patents. The agency relies on what the patent owner reports in the NDA. The figures on the screen show what the Orange Book, in electronic form, looks like. Figure 1 shows the entry by Novo Nordisk that was at issue in the 2012 case Caraco Pharmaceutical Laboratories versus Novo Nordisk. Figure 2 shows the entry from the Orange Book pertaining to the patenting of the pharmaceutical compound. Notice the entry for the patent use code of U546. Figure 3 illustrates what this use code means: use of repaglinide in combination with metformin to lower blood glucose. What this means is that Novo Nordisk has a patent on the compound repaglinide for use with metformin for the purpose of lowering blood glucose. A generic company can market the use of the compound outside of what is claimed in the use code. As background to the Caraco case, note that in response to evidence that the branded patent owners were abusing the process in order to keep out the entry of generic drugs, Congress created a counterclaim that can be raised by the generic drug manufacturer seeking approval to challenge the patent owner's patent rights over chemical compounds and patented uses. The Caraco case illustrates the breadth of this counterclaim. The Supreme Court ruled that this counterclaim included the power to amend the use codes in the Orange Book. Caraco was seeking to market a generic version of an anti-diabetes drug, repaglinide, which was marketed by Novo Nordisk as Providin. Novo Nordisk had disclosed a use code for the use of repaglinide with metformin, which was recorded in the Orange Book. Caraco, in seeking approval of its ANDA, sought a carve-out for the generic formulation that did not include use with metformin as stated in the use code. Novo Nordisk then expanded the use code to include use of repaglinide beyond use with metformin. Because of the breadth of this new use code, Caraco could no longer create a carve-out for generic approval. To overcome this problem, it asserted a counterclaim to amend Novo Nordisk's use code, limiting it to the company's previous statement regarding the use of repaglinide with metformin. The district court allowed Caraco to make the amendment, but the Federal Circuit ruled that Caraco had to show that Novo Nordisk's patent claim did not extend to any method of use. If the patent claim extended to at least one method of use, Caraco could not challenge the use code, no matter how broadly it was drafted. Alternatively, the Federal Circuit held that the counterclaim did not apply to use codes, but only to patent information, such as patent number and expiration. The Supreme Court reversed the Federal Circuit, holding that use codes were included within the counterclaim provisions created by Congress, and that they could be amended if the generic drug applicant shows that the use code wrongly covers some uses. In this case, Novo Nordisk's use code was too broad, claiming to cover uses that were outside the scope of its patents. Accordingly, the use codes could be amended in the Orange Book, and Caraco could get approval for its ANDA. We saw earlier that if the FDA denies a generic manufacturer's ANDA on the ground that the drug is covered by an existing patent listed in the Orange Book, the generic firm can respond by claiming that the patent is invalid through a procedure known as a Paragraph 4 challenge. When a generic manufacturer asserts a Paragraph 4 challenge, the patent owner invariably responds by bringing a patent infringement lawsuit. This infringement litigation gives the court an opportunity to assess the validity of the underlying patent. If the generic manufacturer wins the lawsuit, that is, if the court determines that the patent claimed in the Orange Book is in fact invalid, the generic manufacturer not only gets to proceed with its ANDA, but also is granted a 180-day period of marketing exclusivity, during which the FDA will not approve any other generic version of the drug. This 180-day marketing exclusivity is the generic company's reward for bringing a successful Paragraph 4 challenge, and demonstrates Congress' intent to incentivize challenges to drug patents whose validity is in doubt. In recent years, there has been a great deal of controversy over how some companies have responded to these Paragraph 4 inspired lawsuits. Rather than pursuing the infringement litigation to the end so that the court can determine whether the patents claimed in the Orange Book are actually invalid, the parties to these suits sometimes settle. That is, they resolve their dispute out of court, with the terms of the settlement requiring the generic challenger to drop its ANDA application in exchange for a payment from the patent owner. These agreements are sometimes called pay-for-delay settlements, as the patent owner is effectively paying the generic challenger to delay entering the market. They are also sometimes called reverse settlements, because the patent owner is paying the infringer, as opposed to the usual settlement in which the alleged infringer pays the owner as compensation for infringement. The FTC versus Actavis case illustrates this controversial phenomenon. In that case, Solvay obtained approval of an NDA for an artificial testosterone called Androgel. The company obtained a patent on a particular formulation of the compound. Watson and Paddock were two generic drug companies seeking ANDA approval, who challenged the validity of the company's patent under Paragraph 4. Ultimately, Watson and Paddock settled with Solvay, but the Federal Trade Commission challenged this settlement as an anti-competitive restraint of trade. The FTC based its challenge on the theory that reverse settlements are a form of collusion that enables the patent owner to maintain a monopoly that raises prices for consumers. The FTC rested its theory on the likelihood that the patent owner was going to have the patent invalidated at trial. The settlement therefore served to protect a patent of dubious validity. The appeals court rejected the FTC's argument. According to the court, parties in litigation often settle when the risk of loss is significant. That is simply the way litigation works. The court concluded that absent sham litigation or fraud in obtaining the patent, a reverse payment settlement is immune from antitrust attack as long as its anti-competitive effects fall within the exclusionary potential of the patent. In other words, in the absence of sham litigation or fraud, a pay-for-delay settlement will be valid as long as the generic manufacturer is still able to enter the market upon the expiration of the original patent term. In June 2013, the Supreme Court reversed the Court of Appeals decision and remanded the case for further proceedings. The court held that reverse payments are not automatically illegal, but can nonetheless be challenged as anti-competitive under the FTC Act. The court held that the proper test for legality was a rule of reason analysis. The court emphasized that when reverse payments are made, the patent in question may or may not be valid and may or may not be infringed. As a consequence, it is appropriate for the FTC to investigate such settlements to determine whether they can be explained by factors other than a collusive effort to divide up the profits from a vulnerable patent. In such cases, the defendant must establish legitimate reasons for the payment in order to escape antitrust liability. For example, risk aversion, rather than doubts about the patent's validity, may be the reason motivating the patent holder to enter into a settlement with a generic sponsor. Responding to the concern that applying the rule of reason analysis of the reverse payments would require the FTC to engage in a full determination of patent validity, the court suggested a potential shortcut. The size of the unexplained reverse payment can provide a workable surrogate for a patent's weakness. The court's decision in Actavis is unlikely to be the last word on the legality of reverse settlements in pharmaceutical patent litigation. By rejecting the position that such settlements are either always acceptable or always unlawful, the court has opened the door to future litigation in which the legitimacy of particular payments will be carefully scrutinized. Companies that wish to settle Paragraph 4 challenges will now need to think carefully about how to craft their agreements to avoid antitrust liability.